Hi, this is Stephen Carter, the Black Butterfly, sitting in for the regular host, Mr. O.S. Owen. I'm here with the AARP Foundation, and we have with us as a guest today, Attorney Ted London. Mr. London, glad to have you here today.
Good evening. I'm happy to be here.
Well, I've got to tell you, first of all, I was most impressed by you the first time I met you at a fair that Alderman Harris put on for seniors on Valentine's Day. And what impressed me about you is that you went around to each of those 20 or so tables with about 200 people, and you didn't just drop your literature on them. You engaged them, you talked to them, and that impressed me. Most people would just walk by and drop some things off. But then you were starting to tell me about the work that you do and the things that will help you being the advocate that you are for the community. Tell me about your work in probate as an attorney, what you do, and what folks need to know. That's what I want to know from you today.
Well, good evening, Stephen. Again, I'm Attorney Ted London. It's good for me to be here at the AARP Foundation studio this evening to really share information with the senior community. I am an estate planning attorney, and so often many of our clients are seniors. And one of the things that many people don't know is that we are now in the largest wealth transfer in the history of the world. Seniors are going to transfer more wealth to their children and grandchildren than any other period in the history of the world.
And
we're going through that process right now.
Make it possible for them to transfer as much as possible to them so that probate courts or whatever other legal entities are out there don't get the monies that you or somebody like me would want to transfer over to my kids or my grandkids.
Well, when you talk about estate planning, one of the primary things that you want to accomplish is keeping your home and your money out of probate court. Okay. Probate court is expensive, it is time-consuming, and it's stressful.
Expensive in what ways? What are the expenses of
probate court? You have filing fees, you have attorney fees. If you go through the probate process, people can contest the will, and then there are more and more fees. But primarily, much of the estate can be eaten up by attorney fees. So if you keep your home and your money out of the probate process, then it's going to save time, stress, and money for the family, and more money is going to go to your loved ones.
Let me talk about the stress to the families. I know I've been through this with parents, you know, my parents, and not being aware, or they not being prepared or know. Somebody who's in his 80s, 90s, or whatever, what should they be thinking of in terms of preparing their family for their eventual demise? They should not just leave it up in the air. Tell us a little bit about that.
Well, oftentimes, Stephen, people have misinformation. Oftentimes, people believe that if they have a will, that will keep their home and their money out of the probate process. That's a common misperception.
I had the same misperception.
It is untrue.
Yes.
If one has a will, their loved ones absolutely, categorically will have to go through the probate process. I do not encourage my clients to do wills. Because again, with a will, your loved ones will have to go through the probate process. Again, many people, particularly senior people, that's all they've heard over many, many years, to think that they need a will. And it is untrue that if one has a will, their loved ones will not have to go through the probate process. I want to make this clear. If you have a will, your loved ones will have to go through the probate process. Oftentimes, that's time-consuming, stressful, and costly, and that's where families really oftentimes go to fight over who's going to get the home, the money, etc.
Let me kind of backtrack about the concept. We haven't talked about this, a living will. I've heard that, I know a little bit about it. I think that's important too. What would you tell us in our audience about a living will?
Well, respectfully, Stephen, oftentimes people have a misunderstanding about a living will and they confuse it with a living trust.
That's it. Okay.
And so really when you talk about estate planning, again, the whole objective is to keep your things out of probate court, primarily your home and your money. And so really there are a couple of things that we want to keep out of probate court. The real estate, ourselves, because people can go to probate court while they are still living, and then of course want to keep the money out of probate court. Oftentimes, I don't concern myself with what they call personal property, rings, jewelry, fur coats, etc., Because the reality with those things are, Steve, first come, first serve.
Somebody's going to fight about it, right?
First kid gets the wedding ring, it's theirs.
Right.
First kid gets
possession's 9/10 of the law.
Possession 9/10 of the law. You know what? They'll be disingenuous about having it.
Right.
But if you can
slipped it out
and slipped it out, and then so I don't really spend a whole lot of time on those things when I'm helping my clients do estate planning. Those things don't necessarily have to go through the probate process, but the home would absolutely categorically if there was not some efficient estate planning, primarily with a land trust. Even individuals would have to go through the probate process if they did not have someone in a position to make health care and business decisions for you. In that regard, people need power of attorneys.
Tell us some of the stories. I know you have a wealth of stories that are problems that are either typical or something that most folks should be aware of. What are some of the stories you can share with us?
Here's a matter that we dealt with this week. Did a home visit for a 93-year-old lady, and she's a retired nurse, worked 30 years at Cook County Hospital, worked another 20 years at Mercy Hospital. She's 93 years old now. She lives with her brother. She owns 2 homes, and so she called me in, did a home visit for her. She put the 2 properties in a land trust, leaving them to her brother. That means she still controls them until she goes to heaven.
So that's a land trust, and it doesn't go to probate? Is that what you're saying, or what?
Well, with a land trust, if you name what's called a contingent beneficiary, that is the person that's going to get the property after you, then once a person goes to heaven, then whomever they've named as
heaven is a certainty?
Well, I don't know, but most of our clients are good people, so if there is a heaven, most of our clients are going there for certain. But in any event, a land trust will keep the property out of probate court, notwithstanding wherever a person may go. But you can name as many people as you want as what's called contingent beneficiaries on the land trust, and you still control the property as long as you're living, and then whenever that time comes, whoever you name in the land trust document to get the property after you, they get it very seamlessly without having to go through the expensive, time-consuming, stressful probate process.
Now, what about the problems with folks who are not in their mental faculties are not there? And they have not done anything or prepared there. What do you suggest or recommend to our audience as to what should be done there?
Well, that's an important question, Stephen, because that's an issue that we see frequently in our office. Oftentimes, again, people call in, they want to do estate planning for a parent or a loved one, but they are no longer competent. And so if a person is no longer competent, they cannot do an estate plan. They have to be competent to understand what they are signing, otherwise it's too late.
Well, let me ask you this, just kind of an aside, but can you give our audience a phone number to call if they want to follow up with this, if they want to follow up on things we're covering here today?
Again, I'm attorney Ted London. You can reach me at my office. Telephone number is 773-721-3333. Telephone number 773-721-3333. And or you can Google Ted London. That will take you to our business Google page, our Google business page, and I'll give you a lot of information as well.
Okay.
So Ted London, Google 773-721-3333.
That's all free information.
That's free information.
Right. Okay.
Absolutely.
And you're trying to get across to people in the community. What do the community people ask most for when they have you out?
Well, they ask a lot of questions. Oftentimes, again, one of the most common questions that people ask is, will a will keep my home and my money out of probate court? Again, that's a very common misperception that a will keep your home and your money out of probate court. It will not. But there are things that you can do, very affordable, very easy, very straightforward things that you can do to keep your home, yourself, and your money out of probate court.
When you came out of law school, how different was it in real life, what you learned in law school versus what you saw when you first got in the action?
Well, here's an interesting story, Stephen. One of the reasons I've been practicing law for now 23 years. Time really flies.
You're 20?
Practicing law for 23 years now. Went to Loyola undergraduate school, went to Loyola Law School, came right out, went into my own practice, and I was doing a variety of practice, handling real estate closing, some criminal things, some civil litigation, etc. But this is what started me doing estate planning and probate matters. Well, my grandmother passed away. But by the time she passed away...
How old was she, by the way?
My grandmother was 86 years old.
Okay.
And so by the time she passed away, I was already a practicing lawyer, and I tried to encourage my grandmother to do some estate planning, and she would not do it. And she's like many people, they just did not want to do the estate planning.
Why are they so reluctant? What is the thing? Folks don't want to deal with their ultimate death or what?
I think that's it. A couple of things. Yeah, they don't want to have to think about that this is the end of their life.
Okay.
Oftentimes, people know that they should do these things, but they don't because they just procrastinate. So really, procrastination is the #1 reason that people don't do this simple, affordable, straightforward estate planning.
Tell our audience what kind of problems that causes them when a relative does not take care of that planning ahead of time.
Well, you know, I want to talk about a couple of the kind of issues that,
Okay.
that we find. I had a family in this week, married 44 years, husband and wife. They're both recently retired. They just discovered about a month or so that the husband had a 44-year-old child. And so,
is that a revelation for the wife?
well, it was a I won't say a bitter pill for her to swallow, but it's a
Okay.
pill for her to swallow.
She had to deal with it, right?
Yeah, she's having to deal with it, but she brought her husband in because she wants to make sure that son will not be entitled to a portion of their estate.
Okay.
And so we put the home in a land trust for the family. Husband and wife still control
He
it.
went along with that?
Of course,
Okay.
of course. Husband and wife still controls the property until one of them passes away. Whoever survives is still in control. And after they both pass away, then the property will go to their sole daughter.
Okay.
Okay. One of the other things that we encourage our clients to do is to make sure that they have beneficiaries on all of their accounts. But there are oftentimes many people with blended families.
Yes.
Sometimes children from multiple relationships. Sometimes people are divorced.
I bet you had some exciting stories to
Well,
tell.
we have a lot of stories,
But you can't tell all of them.
well, these are common everyday life scenarios,
Yes,
and
yes.
so these
It's
are
real,
these
yeah.
are not uncommon things. But oftentimes properties can be lost to people who family members really did not intend for them to have an interest in the property.
Like that person in the back of the church who's crying and nobody knows who she is or why she's crying.
Well, here's something interesting about the people in the back of the church.
Okay.
One of the things I have discovered about that is there are many people, particularly seniors, that have more money than we could ever really imagine that they do.
Wow.
You have to understand when our clients come in, really solidly middle-class people, home ownership, homes paid for, considerable amount of money in their financial accounts. They don't come in with big cars and fur coats and big diamond rings. These people who have worked hard, educated their families, worked on the jobs and careers for 30-plus years, they're retired, their expenses are low, they didn't have iPhone 11s, and they don't spend their money on $250 meals.
Okay.
They don't have big, expensive Netflix plans, and what a lot of young people do, and really they acquire and accumulate quite a bit of money. And so while we think of younger people or flashy, big cars, big lifestyles, many of our seniors who don't have the same sort of overhead that many of the younger people have, they've really done a great job in really saving and accumulating quite a bit of money.
Why don't you take another minute and let our viewers know how they can get in contact with you and what numbers to call.
Well, you know what? We have a great team at the law offices of Ted London. You can reach us at 773-721-3333. Any of our assistants can give you information. We can mail you information out. You can also go to Google and just Google Ted London, and that will direct you to our Google business page. A lot of information there. And then, of course, from there, you can always go to our website, tedlondon.net.
I was impressed that you are a community advocate. What does an attorney like you, with the practice that you have, do as a community advocate? Well,
one of the things that we're so proud about is the law offices of Ted London. We are the Cook County Recorder of Deeds community legal partner. So every time the Cook County Recorder of Deeds has a speaking engagement, we go out with them and we share information. We answer a lot of questions that the community have about, let's say, planning, transfer on death instruments, which is something that the Recorder of Deeds office offers.
Transfer of debt.
Transfer on death instrument.
On death, okay. And what is that?
That is an instrument that the Cook County Recorder of Deeds office offers, whereby someone can add someone to a deed that would say that they would get the property after the primary owner passes away, and the person that they name to get the property after them will get it very easily without having to go through the probate process. So that's another vehicle to keep the property out of probate court. Normally, I recommend those kind of documents for people who have reverse mortgages, or oftentimes with people who don't have a lot of equity in their properties. For people that's equity rich, I typically advise them to put their real estate, whether it's a single family home, multi-unit property, where they have multiple properties, in a land trust.
Okay, I'm going on 80.
Going on 80.
What kind of checklist would you have for me if I came in with my wife? What kind of things would you go down the list and say, have you done this, done that, or whatever?
Well, the first thing we like to encourage our clients to do is to protect the home, keep the home out of probate court. So again, we suggest that they put the home in a land trust. You and your wife would control it when you happen to pass away. Whoever survives still is in complete control of it. But in the land trust document, you're going to name who's going to get the property after you. You can name all the kids, I say, or sometimes just the good one. That's up to you two.
It looks like it depends on whether it's the mother or the father.
You never know, Stephen, who's going to be. But that's
what else is in the checklist that I should be looking at?
Then you need to make sure that you have power of attorneys. There are two types of power of attorneys. There's one for health care. There's one for business matters. Here's what's interesting, Stephen. Even people who have been married 50, 55, 60, 65 years, they still need power of attorneys for one another. And again, there are two types of power of attorneys, one for health care, one for business matters. And what they do is they allow you to name someone to make health care and business decisions for you in the event that you ever need someone to do it for you. Just because you're married to someone for 50 years does not give you the right to access their information about their financial accounts or make health care decisions for them either without those power of attorneys.
Okay, it makes a lot of sense, and that you are giving these folks a way to make the life easier, even for those after they're gone.
Well, you know what? It is a present for your loved ones because the reality is the families who are doing the estate planning, they already own it. They already control it. Really what they're doing is they're making sure that the people who they want to have the home and the money, who they want to have the home and the money, get it effortlessly and seamlessly without having to go through the probate process. We have to mention one more thing. We have to talk about the money. So we have to talk about how to keep the money out of probate court. Again,
does the amount of money make a difference?
Does not matter. $5,000, $50,000, $500,000, $5 million. You have to keep the money out of the probate process. For most middle-class people, really, there are two ways I suggest my clients keep the money out of probate court. There are two ways. One way is very simple, and it's free. That's just by making sure that you have beneficiaries on all of your accounts. Checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies.
So if you don't have
one other thing, Stephen, if I may,
go ahead, certainly.
I only say this joke to my clients who've been married for over 25 years, and that is even hidden accounts. You have to have beneficiaries on those accounts.
Like your left-hand pocket and right-hand pocket.
You know what, wherever they may be hidden, Stephen. Hey, another thing, too, even on safety deposit boxes, you have to make sure that you have a beneficiary, because if you don't have beneficiaries on those things, your loved ones will likely have to go through the probate process to access them.
Well, audience, you're listening to Ted London. I'm hoping you're taking notes on what he's sharing with us. Most valuable information. Anybody watching us today, I'm sure that you will benefit by what Ted is telling us and sharing with us today. Ted, please tell us some other things that we need to take a look at.
Yeah, you know what? Let's talk about a living trust. You know what? So many of our clients, we have a lot of single lady clients, and so many of our clients, they've heard Susie Orman. Many of them, some of them come in with the Susie Orman booklet and folder that they were going to do the living trust themselves. Well, some of our clients need living trust. Living trust is a separate document, usually that I use for my clients who want to keep their money out of probate court. But there are some other benefits to having a living trust as well. If one has, for example, special needs loved ones that they're going to care for after they pass away, well, you typically want to have a living trust set up, because if you left the special needs person money directly, it's going to likely cause them to lose their SSI benefits.
That's Social
Security insurance benefits. So if you leave them money through a living trust, it will not cause them to lose their SSI benefits. Another reason that one would want a living trust is if they're going to leave money to minor children. And so oftentimes my clients want to leave money to their grandchildren. They want to fund their education. And so then we want a living trust for them, because you cannot make minors beneficiaries on accounts, and nor should you, because again, they were those money.
So you have to have somebody that's an overseer in essence?
You have to have what's called a successor trustee. So in the living trust document, you name yourself as what's called the trustee, which means you control all the assets in the trust. And then once the person who sets up a trust passes away, that trust does not end.
So is that the same thing as a trust account?
No, it's not a trust account. Well, I want to finish if I can. In the living trust document, you also name what's called a successor trustee. And the successor trustee is the person that will manage the accounts after the primary person passes away.
Okay.
Normally, for my clients, I like to name at least 2 or 3 successor trustees requiring the signature.
In some order?
No,
order.
They're co-trustees,
Okay.
requiring the signatures of at least 2 of them, so not one person has carte blanche to access the accounts.
Okay.
So it's a safety measure to keep one person exclusively from controlling the account.
So you have to be very careful, too, in who you appoint as these trustees.
Well, very important.
Okay.
That's very important. Another reason why, again, typically there are 3 reasons why I advise my clients to invest in a living trust. 1, if you have special needs loved ones, children, grandchildren, parents, sometimes you would need a living trust. If you want to leave money to minor children, fund their education, it's likely that a living trust is going to benefit you. Oftentimes, my clients have substantial amount of financial wherewithal, and they don't want to leave it to their children in a lump sum.
They want to, at certain ages.
Incrementally.
Okay.
And so then those people would need a living trust as well, because if you named anyone as a beneficiary on your account, they're going to get the money in a lump sum.
Okay.
Oftentimes, my clients don't want their children to get the money in a lump sum for whatever reason.
Okay.
And the way that they can set it up is through a living trust, where they can pay them out monthly, annually, every 5 years, at a certain age, whatever condition they want to set that would entitle the person to the money, they can lay it out in the living trust.
Do you have, does it come up where people will contest the trust, probate, will, things like that?
Well, wills are routinely contested.
Really?
Well, the validity of the will can be contested for a number
Okay.
of reasons. It can be contested because they can say the person was coerced into
Okay.
signing it. A person may not have been competent when they signed
Okay.
it.
Yes.
It may not have been properly witnessed. So these are all reasons to contest a will, and simply because someone may not have received what they thought they were entitled to pursuant to the will, and then they'll contest it.
What would you say as a godfather, not as an attorney, about those kinds of situations?
Well, they're fairly common.
If you were advising somebody as a friend or whatever.
Oftentimes you're talking about a lot of money.
Yes.
And one of the things I've discovered is, particularly when parents pass away, sometimes relationships between sisters and brothers.
Dynamics changes?
Well, sometimes they've been bad all along.
Okay.
And things from going back to when they were kids, and I'm talking about people now maybe in their 50s and 60s, they still have some grudges against some of the siblings going back many, many years.
But then it comes out.
Well, and then sometimes children have grudges against some brothers and sisters because they have borrowed money from mom and dad previously, didn't pay them back, and they're annoyed that they may be equal takers in the monies if the parents didn't do a proper estate plan.
That's a real life situation.
Well, that's
that you do all
very,
the time.
very common,
I'm sure.
Stephen. Very, very common. But that's easy to avoid just by some basic estate planning. And typically, viewers, most people don't do the estate plan for primarily one reason. They're procrastinating.
Okay.
Now, it is true, there's some good news, that people are living longer.
Tell us the good news. Keep on with that good news.
This is good news. People are living longer. People are living well into their 80s, mid-80s, 90s. Again,
And the faculties are
in good order.
Okay.
In good order.
Right.
And so my average client's about 80 years old, 78, 82 years old.
I'll be making that list pretty soon.
Well, I would like to see people come in there was a time when I would think that they would come in at about 65.
Okay.
They're not, people aren't typically coming in at 65 to do estate planning. And so they're coming in at about 80. I would at least like to see people coming at about 70 years old.
I'm going to come in before I'm 80 though.
Please do. One of the other things I like to share with the viewers as well is, again, oftentimes people are caregivers, particularly ladies. Ladies are caregivers. They're caring for oftentimes 2 or 3 generations. They're caring for their own family, sometimes their mom and dads, sometimes grandchildren.
Right.
And so, but if you are a caregiver for mom and dad, aunts and uncles, sometimes even brothers and sisters, you have to make sure that you're in position to care for them and manage their affairs. Again, very simple, by having the power of attorneys, one for healthcare, one for business matters. You need them both. You want to make sure that they have the home in a land trust, so you don't have to go through the probate process. You want to make sure that you at least have someone on as a beneficiary on all of their accounts, so the money doesn't have to go through the probate process. If you do those 3 primary things, that's a pretty straightforward, comprehensive estate plan. Put the property in a land trust, power of attorneys for yourselves, beneficiaries on all of your accounts, and then of course you have to list your accounts. What we offer our clients is an estate plan and inventory book, and again, if you want one, you can give us a call at 773-721-3333. We'll mail it out to you at no cost, and of course you can always go to Google and Google Ted London. That takes you to our website and to our Google business page.
Our listeners, our viewers, please, if you haven't taken notes, take these last notes from Ted. Give us that checklist of things that you've got to have on your list.
You got to have home and a land trust. You have to have health care and a doable power of attorney for yourself, for your mom and your dad, for your spouses, and you need to make sure you have beneficiaries on all of your accounts to make sure you keep the home, yourselves, and the money out of the expensive, time-consuming, stressful probate process.
Ted, I want to thank you, Attorney London.
Thank you so very much. It's my
pleasure. I want to
pleasure.
thank our producer, O.S. Owen, for making this show comfortable for me and for our guest today. We will be seeing you next week when AARP continues. The AARP Foundation continues. Thank you, and have an absolutely good day.